Yesterday, the Pretoria High Court heard the case of Sadtu and some of the other organizations like AfriForum. And this case obviously was taken up against the Minister of Education, Umalusi, and also the Department of Education. And the key issue here is the rewriting of two papers, the maths paper and the science paper, after it was found to have been leaked. And what the minister had announced that these papers will have to be rewritten, and as a result, the matter had gone to court. And we joined on the line this morning by Nomusa Cembi, who is the spokesperson for the South African Democratic Teachers Union, Sadtu. Nomusa, good morning to you. Welcome to the show.
Good morning, and good morning to your listeners.
Right. Obviously, yesterday was an interesting day, and from the little that I had seen, I was following some of the court proceedings yesterday, and looking at Umalusi and the minister bowing to pressure from Umalusi to allow learners to rewrite. Now, this obviously featured very, very strongly when the case was being heard.
Yes, it is indeed so. It is one of the arguments that was put forward by us as Sadtu and also by AfriForum to say during when unions were briefed about this, the majority of the unions, even and also the MECs for education in the provinces, the majority of them came to the decision that there was no basis for a rewrite. But Umalusi differed with the popular view and said they were not going to as the quality assurer, they were not going to say that the exam was fine because of the questions hanging around the two papers. So part of our argument was that it's as if Umalusi put the gun on the head of the department to force the department to take this decision. And in actual fact, in the regulations around the exams, the decision on a rewrite should be taken by the Director General together with the Minister. It is not of Umalusi to take or to force the or to take such a decision.
Well, this obviously was the crux of the entire argument, and I think that was a very, very key aspect of the argument that was put forward to the court. But also at the same time, one of the other issues that featured very strongly was the fact that the investigation was not concluded. So it was not conclusive, and we know it's not going to be conclusive for the next few months, and it is still going to be an ongoing investigation. So in the absence of not having a final conclusive report on what had actually happened as far as the leaked papers are concerned, yet Umalusi decided to force the issue, and as you pointed out, put a gun to the head of the Department of Education.
Yes, the crux of the matter is that Umalusi and the department did not explore all the other avenues that are there. They took this decision on the basis of a report, an initial report that was not conclusive. They did not explore the other avenues, such as the remarking. And they also had another option. Our lawyers put forward the argument that the department, since the department said they learned about the leaking of the paper as early as 1 a.m., but most people were in bed, but one can say that by 6 a.m., the spokesperson for the department had made the powers that be in the department aware of the leak, or aware of the reports that he received that there was a leak. We are saying the department should have either given another paper or should have stopped the writing of the paper if they were aware of that. They did not stop. They did not take any action. And now, at the end of the day, learners have got to suffer again and rewrite the paper on the basis of something that is not conclusive, that indeed the majority of the learners got the paper, because laws or regulations regarding rewrites say there must be a conclusive evidence that shows that the majority of the learners did have access to the paper.
What is also an interesting development was learners fighting the rewrite as well, where the learners are arguing the point that the department is using collective punishment when majority of the learners had not even set sight on these leaked exam papers.
We concur with the learners, and our basis for going ahead with this application was that we felt that it was grossly unfair, especially for the learners to go through this. And most of the learners, although we did not conduct any survey as Sadtu, but from what we have received from our member teachers, this paper was not as widespread as it is. And even the report, that preliminary report of the department that was done by the Hawks, it showed that the learners who wrote the paper, who may have had access to the leaked papers, were between 195 to 200 out of the 390,000 papers. Really, we do feel that learners are being punished for something that was not of their doing, because the department cannot establish that the majority of learners did have access to the paper.
And finally, Nomusa, we know judgment is expected today. I suppose you're looking forward to the judgment.
Yes, indeed, we are looking forward to the judgment, and we hope that the judge will provide a judgment that will really make it easier for the learners, who we feel they are the ones who are feeling the most pain, who are very much frustrated, who do not know what to do at this stage.
Well, Nomusa, we're going to look forward to the judgment ourselves as well. But we thank you for your time with us this morning. You take care, and all the best to you.
Thank you very much.
Nomusa Cembi, Sadtu Spokesperson, with us this morning. We come back, we're talking launch of the Mercy and Peace Foundation.
Massive